Okay, so welcome back to our vision of land law. Just before we had a break, I think there was one of you posted a question in the chat asking whether a memo question is an essay. Yes, the answer is that it's an essay, but as I indicated, don't forget that LLB, we don't do conveyancing and also drafting at LLB stage. So when you see these, unique question tax masters, a memo, opinion, and so on. It's not so much about the style of the layout, which really matters, but the substance. And as I indicated, for substance, once it's an essay, you're invited to compose your thought on something, don't forget or don't sacrifice logical structure. That one is absolutely important. So whatever be the case. So let's keep that in mind. So we will continue. Let me share the screen and then we will continue. Okay, yeah, so that was we look at the question 1. Maybe another question which we are going to discuss together, and I'll take your thoughts. One is more interactive, it's more interesting than when I'm just talking. You're just in a room by yourself and you're talking alone. But when you hear other people talk, then it lets you feel that you are not just by yourself, but you're in the community. Good. Yeah, so the other question is explain how Land Act 2020 Act 1036 protects persons interested in acquiring interest in land from fraud and the phenomenon of multiple sale of land. Okay, so ladies and gentlemen, if you have a question like what I have just put there, how will you go about it? If you have a question like that, how will you go about it? Yes, explain how the Land Act Act 1036 protects persons interested in acquiring interest in land from fraud and phenomenon of multiple sale of land. Yes, will anybody give us the kind of structure, the points? Yes, any thoughts? You can just unmute yourself and talk. Yes. I think the question is clear. It's not complicated, isn't it? In terms of understanding what it is calling us to do. Yes, Savior. Any thoughts? Mauko. I don't want to share what you are learning with others, eh? Yeah, who try?
Hello, Doc.
Yes, please, go ahead. Now, let me share this with you. Last year, when I was doing this revision, the students who were very active in contributing, none of them failed. They were not even part of the 499. They were part of the first batch. So if you share, I think it is another way of learning. Yes, Akwasi, go ahead.
Yeah, Prof. I think with now the New Lands Act, some of the measures is taken in place to avoid multiple sales. Now you need to attach site plan before the matter will be adjudicated on. And now the New Lands Act makes that also states that the allodial holder will have to register the whole interest in the land before it can alienate. And also, now the New Lands Act also ensures that the occupant of the stool and all the principal elders who are required to sign, do the needful before they can alienate a portion of that land to anyone. And I think that Section 2 also protects, has incriminate land guard issues.
That's Section 12.
Okay.
Yeah.
Okay.
That's Section 12.
Okay, yes, Doc.
All right. Thank you very much.
Thank you very much.
Sharon. Yeah, so yes, thank you. Any other person? Maybe like let me give you just a little guide in addressing a question like this. So as you look at, yes, somebody hand is up. Yeah, Kwasi.
Doc, mine is Kojo. I think
Yeah, Kojo, yes.
It should be the structure.
Okay.
First, yes. What were the challenges or weaknesses with the old system? We may have to at least list them.
Okay.
And then we look at the cure that the new act has brought.
Okay.
So my colleague who spoke earlier enumerated those things, including the registration of allodial interest and then all those things. But the only aspect that I want to add is the fact that we must point out the weaknesses or the challenges of the old system. Then we address what the current act has brought. For instance, when you mentioned the criminalization of land gas, activities of land gas, and also now the fact that the law is explicit on when it comes to stool land, the stool land, that of the family land, that the fact that the occupant and then the key elders must, their consent and then concurrence must come on, so that if we address that, it means that yes, there were fraud in the other one, and this time the fact that if you engage in multiple sale as a chief and so on, you're going to be dealt with by the law. And then the multiple sale of land has also been criminalized. So these are what I just wanted to bring, the fact that we should look at the challenges of the first or the previous acts, the multiple acts. And then now we have it in the fact that we have a single act also help in dealing with the situation. So this is what I just wanted to
All right, thank you
Bring-
very much, Kojo and Kwesi. Yes, I mean you're all on track. That you must have a structure, and then you have the introduction, and the introduction you acknowledge. Yes, KK, your hand is up.
Good evening, Doc.
Good evening, KK.
Good evening, Doc. Can you hear me, sir?
Yes, KK, I can hear you.
Right. I think for structure-wise, I'll start with an introduction to the introduction of the New Lands Act 2020 and the long title, that is the objective of the act. And I would go to my question appreciation. And in the question appreciation, I'll tell them the method that I will use. And personally, the method that I'll use is that I'll start with the benchmark with the case of Amazon and Oklika, which is a good case to demonstrate fraud when it comes to these land transactions. And I would go down and look at the act, how it that'll be my first paragraph. My second paragraph will be the criminal sanctions the act gives in order to cure or in order to secure our interest in the land. I'll look at 277, section 277,
Okay.
and I'll look at section 12, which gives example of such criminal institutions. Then I would also look at some regimes like the customary land regime, that customary lands, the customary land secretariat in particular, on another paragraph. And if you read section 14 of the act, it brings some form of certainty implemented very well, so that people would know who has the right and who has the right to eliminate customary lands and all that. So that is how I would do it.
Okay.
Thank you.
All right, KK, thank you very much. Yeah, so I think we get the very relevant points from all the three contributions that you've had. And you all have a reasonable understanding of what the question is asking us to do. So the question, if you look at it, is recognizing that we have a problem of fraud, as well as the multiple sale of land. And so the question presupposes that these problems are known before we had Act 1036. So as the other gentleman said, how did the problem of fraud, or what brought about the multiple sale of land, what were some of those factors, some of the things which actually made that happen? We are not going to give any elaboration on that, but just to quickly outline some of them as part of your opening and so on. And then you need to appreciate that if we look at the memorandum to the bill, the land bill, before it became the act, if we look at the memorandum, for example, you notice that the sponsor of the bill actually mentioned these problems as part of the justification for trying to bring about this act and so on. And then you come to, if the lawmaker was cognizant of these problems before the enactment of Act 1036. What evidence do we have from Act 1036 for having provided a cure, as the other gentleman suggested, having provided the cure or having provided the panacea to those problems which we consider as being fraudulent transactions in land, the multiplicity of land, and so on. And you've all provided like the kind of solution or those things which are provided in the new law to try and safeguard or protect the purchasers of land from becoming victims of fraud or from becoming victims of this phenomenon of multiple sale of land. So the provisions that you cited, section 12, quite important. Section 277, the offense is very important, but then don't also forget aspect of the registration of documents relating to interest in land. And yeah, don't also forget that, because that's the fact that if you submit an instrument affecting land and you've done all that is required of you, and the law recognizes that you're entitled to priority from that moment that you completed the submission and not when the registration actually took place. All those things are very important mechanisms in trying to protect a purchaser of land against fraud. Just look at the problems that we had with the old cases that we mentioned. In Temenakwanda, Asari Nebrobe, Oklo, and all those things, Osha and Dako. Just look at all those kind of old cases and how the weaknesses inherent in the law which govern registration of these at the time. For example, facilitated fraud or multiple sale of land, as it were. Just look at even mechanical law enacted that we just cited. Yeah. So that is it. And of course, every good essay must have a conclusion. And what is the conclusion supposed to do? The conclusion is supposed to just pull the main argument you've made together, and then you tie it, and then that is done. But oftentimes when you are marking, or examiners are marking students' scripts in these exams and other exams, what they find is that students are often, either they don't manage time well, and because they don't manage time well, they miss out on some of the things because they do not even finish. But the point to remember is that marking scheme is prepared for the question. And then the marking scheme distributes the marks across the various, segment of the expected answer. So therefore, if you did not, let's say that do conclusion, you're not going to fail that question, but you lose, let's say, marks, assuming a good conclusion should be given 3 marks. And we didn't provide conclusion at all. So there's not even a question of whether you've written a good or bad conclusion. You don't have conclusion. So you're not going to get any of the 3 marks. You see how mass distributions are done in marking scheme. So that is why you need to get your points, organized, and then you discipline how you develop your ideas so that you are able to stay within the time. And this year, let me suggest to you that because you are not doing multiple choice exams and you are going to do only 2 questions, nobody knows whether one problem or one essay or whether both problem or both essay. Nobody actually knows. But what we do know is that you are not going to do multiple choice, and all of us know that from the news. Now, it tells us something that if let's assume that some of these questions you are discussing, or whatever questions that you'll be discussing with your friends, or you'll be learning and so on, you go and that is there, and you decide to spend, let's suppose the paper is 1 hour 30 minutes, or let's say 2 hours. You decide to spend 1 hour, right, or more than half of the time on just one question, because you're excited that your question or an area that you actually targeted has actually dropped in the exams. Now, what you should remember is that if each question is being marked over 50, right? And that's what's going to probably happen, so that you have 100. Or you mark over 20, 25, 25, so that 50 or whatever. If let's say the maximum marks is, let's say, 50 for the question, we are not going to give you 55 because we decided to use more than 2/3 of the time to answer just one question. And then the other question, you wrote few lines thinking that when the examiner see the effort I have made with this one, he will know that, oh, I have done justice with the other one. No, it doesn't work that way at all. You could even be the highest scorer as far, or the highest score the highest mark in a particular question across all a group of students, but you still not pass because you didn't get marks from other questions. So let us pay attention to that as we prepare. Okay, so you move on. Yeah, so another question I think the last year I brought up for discussion was this, that a group of investors from the USA are planning to set up various projects, including factories in Ghana, but they are concerned about uncertain state of the law relating to land in Ghana, especially in the wake of enactment of Land Act 2020, Act 1036. Prepare a full memorandum briefing them on current state of land law with particular reference to issues that may be of concern to them as investors that will need, investors who will need their land for their investment projects. So let's assume that you have, a sort of this type of like a general question. How will you go about it? I mean, admittedly, if you look at the question, is general. The question is general, and if I'm examine you, in exams like this type of question too will not be out of place. So you as the candidate, you as the student, what are you going to select from the broad knowledge and the detailed knowledge that you have in land law in order to respond to this particular question? So I'd like to, as usual, take some thoughts from you and then I'll comment. Yes. And I think the last, so let me hear from you. Then when I finish, I will go through some of the things that we discussed last year with respect to this particular question. Yes. So how will you go about it? Yes. Bernice? Yes, the question obviously looks broad and all that, but you still have to answer it. Any thoughts? Yes, KK.
Good evening, Prof. Once again.
Good evening, KK.
I'll start by introducing them to the new lands at Accident. And in my introduction, I'll put in a question association. So in the question association, this is how I'll put in how I understand my question, the question. And
So what is your understanding
the way that
of the question?
Right. So my understanding of the question is that these are they are prospective acquirers in quotes of land, and they would want to be certain how the legal regime protects their rights or their interests in land. That is how I appreciate the question. And how I intend going about it is first introducing them to the constitutional regime, that is Article 18, that guarantees the right to property. Then I'll trickle it down to 1036. The first thing I would consider is the kind of interest they could gain from the land. So I'll take them through a journey from Section 2 through to Section 8, which constitutes the individual interest, the allodial, the usufruct, the various interests, basically, to summarize. Then I would take them to how they can acquire an interest in land. And I'll take them through sections 32, 33, 34, 35, which basically talks about how they may contract to get an interest in land. And since they are foreigners, I would also take them through Article 266. That is to tell them that they can only hold on to that land if they are foreigners for a period of 50 years, which is reenacted in Section 10 of the Act 1036.
Can you speak up, please? Yeah, raise your voice a little bit. Yeah.
Sorry, sir.
Yes.
I said I was going to take them through the Constitution, Article 18, and I'll take them through the various interests in land, because it's very important they know that sort of interest they are getting. So I'll take them through Section 2 to about Section 8. And I will pronounce more on the leasehold because it is much more practical that they will get a leasehold. Then I'll take them back to the Constitution. Since they are foreign entities, I'll take them to 266, which we will talk about the fact that they can only hold the land for 50 years at a time since they are foreign, which is reenacted under Section 10. And I'll take them to how they can acquire this land. I'll take them through Section 32, 33, 34, 35. That talks about how they can get let's say, a leasehold by contracting or through customary rights, all that. Then I'll take them to the criminal regime under Section 12 and Section 277. In case they have any issues or they've heard about this landguardism and all that, I'll take them through that and reassure them that from there they can register it through a deed registry from 206 or a title registry. If the place has been declared as a title registry from Section 83 downwards. That's how I'll go about it and conclude after. Thank you.
Yeah, okay. Thank you. Yeah, I mean, that is a good attempt. But again, being foreign investors, right? Foreign investors, you touch on an aspect, but you left out the other one. Yes, we touched on the constitutional guarantee to the right to property. But foreign investors are always concerned about compulsory acquisition, right? The exercise of eminent domain. So you have to look at the Article 20, no guarantees regarding compulsory acquisition. Because one of that, if you look at the of those who did the international investment law and all that, and public international law, if you look at the history of the law, for foreigners who are invested in another country, they are always concerned about the whole state not using the sovereign power to interfere with their property right, their investment and all that. So I think it will also be useful to let them know about the regime we have on compulsory acquisition and the protection which is given, should it even become necessary, the various compensation and all that. So that will also be an aspect that we need to touch on. But as I said, obviously, this is a very ambitious question. And if you had a question like this, it will require a little bit of discipline in how you present your ideas. And you go for what you call the capital selector, like the most important things, like things which you think will definitely be of a concern to, like the kind of things that the KK talk about. Yeah, so those are the things. So last year, for example, when we were doing this kind of exercise, I'm told 5 minutes to be ending. Then okay, let's try and finish here. Yeah, so somebody, we had a number of plans. So one suggestion which came was the ownership of land in Ghana, brief background, acquisition of land, registration of land in Ghana, harassment of developers, and then advice to them. So I'm actually made students to put their thoughts together, and these were some of the which came up. And so if you look at the, let's say the plan 1 by one Alice at the time, you notice that the things that he proposed to discuss have also been touched on by what our friend KK suggested. Then another student plan, brought out the plan 2. He said that, okay, introduction, he would try and briefly demonstrate his understanding of what the question is really asking for. And then he'll give the brief background to the state of the law prior to Act 1036 and emphasize the scattered state of the statutory law. And then he will talk about the purpose of Act 1036. And then he will give advice based upon areas in the Act, how our aliens or foreigners can acquire land. And then he will also discuss some problems of land transaction addressed by Act 1036, such as double acquisition, fraud, and so on. Then we had plan 3. You see that the same question, but various ways of resolving it. But you can still get the key ideas running through almost all the various attempts. So, for example, plan 3, the person, we said, okay, brief historical background on land acquisition in Ghana, constitutional and statutory provision regarding acquisition of land in reference to foreigners, various reasons for special provision governing land transaction involving foreigners, and then plan 4, also just mentioned Article 57, and then the land acquisition procedure. Yeah, so you notice that despite the differences in the quality of the responses, we have similarity of ideas, which are also part of like the essential points based upon what we have discussed in commenting upon KK's response. Okay, so we have 2 minutes, 20 seconds and we'll be ending for tonight. So I'm going to pause and then and we have a bit more questions on land law. Maybe we'll try and do 2 or 3 more land law sessions. Okay, so any other question or comment before our 2 minutes will end and then we end for tonight? Or is there anything bothering you which you would like to get maybe some presentation or discussion on in the coming days?
Yeah. Doc, this is not a question per se.
Okay.
Just as a contribution to what KK presented.
Right.
One would like to know, we have the areas of the economy that they want to. Basically, we are talking about land.
Okay.
And that their interests, are they going to, let's say, agric? Are they going into mineral processing, gold mining, and so on? So by way, if they are going there, it means that if they are going into mineral, it means that Article 2576 will be relevant. We have to draw their attention to it. That yes, in Ghana, this is the position.
Okay.
When you are going into land and then natural resources. Then we should also look at, since we are mentioning that we are talking about the ownership and so on. So the 266, Article 266 is also important for us. Then the fact that they are foreigners, they cannot acquire a land beyond 50 years. So we should draw their attention to it, that this is what happens. Especially, they shouldn't be even, anyway, I won't go there. I wanted to come to capacity, talking about the 40